All right, we have one case on the docket today, State versus Sarah Jo Fuson. And we are ready to proceed with the sentencing hearing. The state may call your first witness.
We'd ask that Your Honor incorporate the proof from the trial into this hearing today. And we would call Miss Macy Hyde. And have you prepared a victim impact statement today that you'd like to read?
Yes, sir.
With your court's permission, I would ask her to read.
All right.
Your Honor, my name is Macy Hyde, and I am the mother of the child who has been deeply harmed in this case. There are no words to describe what it feels like to realize your baby has been harmed by the very person you trusted to care for her. I had trusted Sarah with the most precious thing in my life, my daughter, and that trust was shattered. I am here today to share the profound and lasting impact the defendant's actions have had on my daughter, on our family, and on me as her mother. Though too young to fully understand what has happened, continues to suffer the effects. For months after the incident, she woke up screaming in the night. She had panic attacks and was showing an overwhelming fear of sleep. Putting her down at naps and bedtime became an emotionally charged ordeal. As a mother, the emotional turmoil has been unbearable. Every day, I live with the constant anxiety that my children may be hurt again, fear that grips me every time I drop them off at school or leave them with anybody other than myself. Things that once felt routine, like school drop-offs, babysitters, and play dates, are now moments of intense dread and second-guessing. I regret deeply back to Sarah the day after the abuse. The guilt that haunts me for that decision weighs heavily on my heart, and I still to this day struggle to forgive myself. After watching the trial videos, my husband and I experienced nightmares, uncontrollable tears, and unable to shake the images from our minds. We both sought therapy to cope with the trauma, including EMDR, to help erase the haunting memories. Rewatching the footage in October just reopened old wounds, bringing back intense pain and the memories of that time. Our daily life has been irrevocably changed. My children have become more cautious, and I have become hypervigilant. Every change in behavior raises a red flag in my mind. The fear I now carry is not a life that I ever imagined for my children. Yet it is our new reality. The trust we once had in the world around us is shattered. Sending my children to school or leaving them in the care of others now feels like a risk that I cannot fully bear. The ripple effects of this trauma has permeated every part of our lives. I ask the court to fully understand the deep, lasting harm that this has caused. I thank you for allowing me the opportunity to share the impact this trauma has had on our lives, and I hope the court's decision reflects the gravity of the suffering and the fear that my family continues to endure. Thank you.
And you are the mother of Sarah Fuson, is that right?
I'm Sarah's mom, yes.
And where do you live?
I've lived there my entire life.
And how are you employed?
I'm a school teacher, elementary school teacher.
How long have you been a school teacher?
And this is year 28.
Describe your relationship with your daughter, Sarah.
When Sarah was born, she was the biggest gift in our life. We just enjoyed, she was the sweetest child. She gained the nickname Sweet Sarah. Everything about raising her was a joy to me. We were actively involved in our church, and one of the greatest blessings was she was baptized at age 7, and that gives me lots of comfort.
If you would describe for the judge the impact that this prosecution and trial has had on Sarah.
From the beginning, there was an immense amount of media and social media coverage because of who her father is. This caused extreme embarrassment and shame. I knew that that day, January the 10th, when I came home from work and heard what Sarah's account, that very confident, independent girl that we knew and raised was gone. As time went on, she felt that life had no meaning and like she had a gorilla on her back. We committed her to a mental hospital for a couple of weeks. She came home on lots of mind-altering medications. The medications would change off and on. In the process, she's gained about 50 pounds. got her kind of back a little bit mentally stable. Trying to get a new job was very embarrassing, to say the least. She would attempt one after another. With the charges on her record, it would come back when they did a background check. So she would get fired. And some of those firings were very, very humiliating. During this period, I made sure Sarah was with me or someone at all times. I did not feel safe leaving her by herself. Everything is worrisome and extremely painful. I am so sorry for all of your pain and all of the trauma and all of the mistrust in society that this has caused you. I've tried. I wanted to from the very beginning to reach out. I was advised not to. I even wrote you all a letter. And I know it wasn't given to you. We do not, as a family, condone what Sarah did that day. We don't, but we do love our daughter. Also know that Sarah did not think her actions at the time were hurtful. It was only when she saw herself on video that she thought, yeah, that was rough. Sarah was raised in a home of public servants. She only wanted to serve others. Sarah is not a throwaway person. She is kind. She is generous. She is loving. As her family, we need her. We depend on her. And we will have a big hole at our table and in our hearts until she is returned home to us.
Thank you. Those are my questions. Go forward with your statement.
I want to start by apologizing to Ms. James, the probation officer, about my comments about the case. I was still adjusting to jail and was going through a difficult time. That's not how I feel about the case. I had been working at Tylertown for 6 months when this happened. I loved my job, I loved the children, and I got along very well with the staff. I used to look forward to going to work every day, to be with those children and be in the environment. I was always alone with 6 children in my classroom. Sometimes it was difficult to give one child the attention they needed when I had 5 others to care for. I find myself hurrying and multitasking all the time. It was also hard to give the new children the attention they needed to transition into the toddler room. I didn't realize I was being rough with in the moment. I recognized that I was rough with her and regret my conduct. If I could go back and make this right, I would have been calm and gentle as usually I was and not rough. I love children and animals, and it is not in my nature to be rough. I want to thank my parents and my family for supporting me and standing by me through this very difficult process.
Thank you.
That's the sentencing spread is 15 to 25 years. Under recent amendments to the law that apply in this case, it is a 100%. There's no parole. There are no credits. Serve every day. My position is pretty simple. The government's pleadings say they want a sentence more than 15 years. They haven't said what number they want, but they want it more. I think that a sentence of more than 15 years is brutal, unnecessary, and consistent with the sentencing law. I want to think about 15 years for a minute. I think everybody on this side of the table went to college, most of us. That's 4 years. 15-year sentence is 4 times of being in college. When you put it in real terms of spending time, it's forever. The college was an education, and for most of it, it was having a good time. Being in prison for 15 years is being locked up in a cage. I was at the penitentiary at the women's prison 4 days ago, parole hearing. There's barbed wire everywhere, it's silent as a tomb. You don't throw sentences around like candy anymore. There's no such thing as a mid-range sentence to make everybody happy at one end or happy at the other end. We are talking about real years here. But now the sentences are at 100%. The sentencing mindset that we had 5 years ago is inapplicable today. Our sentences have gotten inflated, but there's no change in the sentencing lengths. It doesn't work the other way, unfortunately, when the sentences are at 100%. So we don't have to talk about the fantasy that we engaged in where you say, well, you give somebody 9 years and maybe they'll be out in 3 and maybe they won't. So maybe we can adjust the sentence accordingly. This is real time. It's just like the federal government. When Mr. Strines and I go to federal court, it's 100% over there too. But the federal government had some common sense. You can believe that. They reduced the sentence lengths to account for doing away with parole. And we engaged in utter madness in our state, where we left the grids the way they were and went up there. This is not the time or place for me to complain about that. We'll pay the price for that one day. And there'll have to be another sentencing commission to undo all this mischief. But the problem is, Your Honor is imposing a sentence today that's 100%. That will not change. We incarcerate more women in this country than any other country in the world, with the exception of some Middle Eastern countries would actually kill women. The sentence says under 102 must be imposed that is justly deserved in relationship to the seriousness of the offense. Justly deserved. Why in the world does this girl need more than 15 years at 100%? The law also requires elimination of unjustified. Punishment must consider restraining defendants with a lengthy history of criminal conduct. That we not have that here. Ms. Fuson does not have any prior history. Next, the court has to consider whether other measures less restrictive than confinement have been applied unsuccessfully. She'd been on probation 5 times, violated them. Of course the court would consider that. So we've tried everything we can. Your Honor does that every day. That's not what we have here. And most importantly, the sentencing principle says the sentence imposed should be no greater than that deserved for the offense committed. That's the so-called parsimony provision, the least possible sanction. No greater than that deserved. We have to balance everything. Why in the world should this woman deserve more than 15 years in hard labor in prison? In 15 years, Your Honor, nobody's going to care or know.
Are we now having inmates perform hard labor like chain gangs in the prison system?
No, they
that I'm
don't,
unaware
but that's
of?
what the statute seemed they get. The statute said you got to give them a Bible, that they're, they have these archaic.
I just didn't know when you mentioned 15 years at hard labor that was actually an accurate representation of our prison system.
No, not any, well.
I understand it's an eloquent reference to other images that we create by putting people in prison, but go ahead, I'm sorry.
Your Honor, I don't want to go too far afield, but I have had constant calls of prisoners being subject to abuse and killed in prison.
I understand that prison is not a pleasant experience.
It's without using profanity in the court, it's heck on earth. It's a terrible place. It may not be hard labor per se, but it's a hard life. People are extorted like crazy over there. If she said, I did not knowingly intend to harm this child, that's true. But she did nevertheless. But she was acting in a reckless way because the statute said should have known. And should she have known that she was harming this child? I suppose so. But I suggest this is much different than the child abuse cases that Your Honor sees, where the child is being shaken all right to the point of death. And they know what's happening, and they intend to harm the child that she didn't intend to harm. I suggest that should be weighed in the balance as well. It doesn't diminish the pain that the parents feel, but it's not the intent.
English transcript. I'm not sure that I have before today. I didn't see any indication that Miss Fuson accepted any responsibility for this. In fact, to the contrary, she not only didn't accept responsibility for her actions, she minimized those actions. She gave excuses for those actions. She talked about how badly she was being mistreated and how unfair things were. I think it's instructive, even though this has been made an exhibit, that when the presence report was prepared as an opportunity for a defendant to give their version of the events, and when our probation officer went to Miss James, went and talked to her and took her precedence report and gave her an opportunity to be heard. Here's what she said. It was O's first day in my classroom, and I was having issues with her sitting up in her chair at breakfast time. So I quickly yanked her back in her chair to keep her from falling to the floor. A second video is of nap time, and I was trying to get her to lay down. She wouldn't. So you can see me laying her down several times, and some parts do look rough. They say,
Here is a human being. These laws were designed to reflect a sentence for her. The indictment is the state of Tennessee versus her. And the court is the arbiter of what that sentence should be. That's why we have judges. Sentencing guidelines are advisory, but at the end of the day, it's a very human experience. 15 years at 100%, I never thought I would stand in a courtroom in this state and say that such a thing. That's where we are today. No sentence more than 15 years is deserved and would be inconsistent with the rest of the guidelines. And I thank you, Your Honor.
With all due respect to counsel, I've been around for a long time, and I've heard this before, and perhaps it should be addressed to the legislature, but that's not where we are here today. Your Honor, presided over this trial. You've heard all of the evidence, read the pre-sentence report, considered the statements and testimony here today. And on behalf of the state of Tennessee, I would submit that, yes, at this point in our history, the legislature, for some crimes, has decided that, yes, a person must do real time for a real crime. And this was a real crime. State certainly submits that whatever sentence Your Honor imposes will be based upon the law and the evidence, consideration of all the factors. But on behalf of the state of Tennessee, Olivia Hyde, family of the state, does sincerely believe this should be more than the minimum sentence. Thank you, Your Honor.
Well, any court that has to impose a sentence in a case like this is required to follow, as has been pointed out by both sides, the considerations and the guidelines that our state legislature has put in place to govern the sentencing in criminal cases. Those sentencing considerations are set forth in Tennessee Code Annotated 4035-103, and that provision states the following: to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Obviously, this, as has been pointed out, is a case that requires whatever sentence I impose, the minimum sentence is 15 years, and the service is 100%, meaning she's not eligible for parole at any point in time. So some of those considerations are not really relevant. Obviously, the only one this court would be inclined to consider of those factors would be that, it is in this court's opinion important not to depreciate the seriousness of the offense. This court observed this trial. I observed the defendant's behavior during the course of the trial and her testimony from the stand during the trial.
let's talk about 403. 5210 says that the minimum sentence within the range of punishment is the sentence that should be imposed because the General Assembly set the minimum sentence for each felony class to reflect the relative seriousness of each criminal offense of classification. That's what it says. This is not that complicated. That's what the statute says is the minimum sentence. That's what the legislature said. This risk assessment is a low. That is a factor the courts require to consider. Is she a threat? No. She'll never work in a daycare center ever again in her life. She'll never be near children in the rest of her life. Impossible. Her risk is low. Is that a mitigating factor? Of course. If it was high, the state would be up here saying and waving around. They're not 15 years of any human.
Sitting up in her chair at breakfast time. So I quickly yanked her back in her chair to keep her from falling to the floor. The second video is of nap time, and I was trying to get her to lay down. She wouldn't, so you can see me laying her down several times, and some parts did look rough. They say I caused bruises, but also say I caused a head fracture. I made sure she did not hit her head, and it was medically proven that she didn't have a skull fracture. But here I am in jail for it when it's not what that was. It was a wormian bone. Then during the interview on November the 13th of 2025, the defendant reported that she was not frustrated during the incident and was only trying to keep the child from falling out of her chair during feeding and trying to get the child to take a nap during nap time. On multiple occasions, the defendant made the statement, and I'm going to quote it exactly as it's written. I shouldn't effing be here. I didn't do anything. She also stated she had talked to friends and plenty of them say they have handled their own kids that way. She stated that the victim's mother is a liar and that the child was fine the next day and that she brought her to the daycare and handed her to the defendant. She reported they lied in court and the child had no fracture on her skull. She stated the bruising on the child's arm just looked like a rash and that the defendant's family is, quote, pissed because she shouldn't be there and she didn't do anything. She reported she wasn't allowed visits at the jail and that her family needs to sue the jail so she can get out of there. She also discussed how the food sucked and she really wanted a Dr. Pepper. The interview became solely focused on how this incident has affected the defendant with no concern for the child. That is the pre-sentence version of the events that Ms. Fuson gave. Now today, we saw a different side of her, and obviously if anyone who has a good lawyer is going to tell the defendant that you've got to come forward and make an allocation where you show remorse, I just don't find in this court's opinion that her expressions of remorse today are particularly sincere. I think they're motivated by good advice of counsel as well as the fact that she realizes having said those things, that those things can come back to bite her. Based upon all of the factors that the court has considered, my observations of the trial, the demeanor of the defendant, both at trial and during her testimony, her statements in the pre-sentence report, and all of the other factors in this court, I'm of the opinion that as to count one of this indictment, the defendant should be sentenced to 20 years in the Tennessee Department of Corrections. In count two, I found that she should be sentenced to 4 years in the Tennessee Department of Corrections, and those sentences will run concurrently with one another. And that is the judgment of the court. As to the motion for new trial, I know that there's already been a motion for new trial that has been submitted. However, the court is of the opinion that the state needs an opportunity to respond to that motion or to prepare for that motion. I'm here in January, and we can set it for argument on January the...
Also, I'd ask, Your Honor, when the court adjourns, if my client can be put in the back. Mr. Strides and I need to confer with her.
That's fine. There's a room that we can allow that to take place.
Thank you.
All right, this court stands adjourned.